What is MCL 257.312 restricted license? Losing the ability to drive can disrupt work, school, medical care, and daily responsibilities, which is why understanding Michigan's restricted license law matters for anyone facing a suspension or revocation. MCL 257.312 explains how limited driving privileges may be granted when someone shows extenuating circumstances and special reasons, allowing tightly controlled driving while maintaining public safety. Under MCL 257.312, the Secretary of State may issue a restricted operator's or chauffeur's license when a person cannot qualify for full driving privileges but demonstrates a hardship that makes limited driving necessary. The law allows restrictions on time, geography, purpose, and in some cases mechanical modifications to the vehicle. Although the license is limited, it remains a valid Michigan license. Driving outside the approved terms is treated as driving without proper authorization and may lead to citations or additional suspension periods. Eligibility requires proving that essential travel such as employment, school, or medical appointments cannot occur without driving. Requirements vary depending on age, driving history, and the type of license action involved. Minors ages 14 to the 15th of May receive restricted privileges under hardship conditions through a parental petition, while adults may qualify after certain suspensions or revocations if statutory criteria are met. Michigan treats suspensions and revocations differently. A suspension may allow a restricted license after a mandatory no driving period, while a revocation usually requires at least 1 year and a restoration hearing, with limited exceptions for specialty programs. Some individuals, including repeat DUI offenders, may qualify through sobriety court or other specialty programs. After 45 days of revocation and installation of an ignition interlock device, limited driving privileges may be possible if the program certifies eligibility. Certain situations make a restricted license unavailable, including refusing a chemical test under the implied consent law, never having held a valid license, or being suspended due to medical or legal disqualifications that must be resolved first. Since 1999, restricted licenses have been issued by the Secretary of State rather than the courts, except in narrowly defined programs. The no driving period must be served before applying, such as 30 days for a first OWI or 45 days for a high BAC offense. Applicants must submit a request, pay fees, and provide required documentation such as proof of ignition interlock installation or confirmation of program participation. The Secretary of State may mail a paper license or update the driving record, and applicants should confirm that the issued restrictions are correct to avoid unintended violations. A restricted license allows driving only for specific purposes. Approved travel includes work, school, court-ordered programs, probation requirements, and medical appointments for the driver or a household member with serious medical needs. Unapproved uses such as errands, social visits, or recreational trips are not allowed, and even minor detours may be considered violations. The Secretary of State may also restrict driving to certain hours or geographic areas. Drivers must carry proof of destination, such as a work ID, school schedule, or medical appointment reminder. Certain restricted licenses also impose mechanical or passenger limitations depending on the driver's circumstances. Several common situations lead to restricted driving privileges. A first-time OWI typically results in a 6-month suspension with eligibility for restricted driving after 30 days. High BAC offenses require 45 days of no driving and installation of an ignition interlock device before limited privileges may be granted. Repeat offenders with revoked licenses may regain limited privileges only through sobriety court after 45 days in compliance with court orders. Drivers who accumulate 12 or more points within 2 years may face a suspension and may qualify for a restricted license if they demonstrate hardship. Some drug-related suspensions may also allow restricted privileges depending on the offense. Refusing a chemical test leads to a 1-year hard suspension with no restricted license allowed under any circumstances. Understanding the structure of MCL 257.312 helps individuals navigate the steps needed to regain limited driving privileges while avoiding further penalties. Michigan defense law provides guidance to those working through suspensions, revocations, and restoration efforts. For support during this process, Paul J. Tafelski at Michigan Defense Law is available at 2525 South Telegraph Road, Suite 100, Bloomfield Hills, Michigan, 48302, United States. Reachable at 248-451-2200.